Steve Gruber Show on X. Dan Lennington joins us now, Managing Vice President, Deputy Counsel at the Wisconsin Institute for Law and Liberty, will-law.org. Dan, thanks so much for joining us here on the Steve Gruber Show.
Thanks for having me. I appreciate you giving me the chance to talk about our programs here.
Yeah, Wisconsin Institute for Law and Liberty. People might have seen the Institute featured in the New York Times, not yesterday, but one Sunday before that in an article about the fight against DEI programs. How did Wisconsin Institute for Law and Liberty become one of the standard bearers, flag bearers for this fight against DEI?
Yeah, well, we started in about 2021 with our Equality Under the Law initiative, which focused on the race-based programs that were just being perpetuated out of the Biden administration. Joe Biden, when he came in, he had some really massive legislative successes. He passed the American Rescue Plan Act, the Inflation Reduction Act, and the Bipartisan Infrastructure Act. And all of these acts contained very specific race-based preferences and programs. We calculated that perhaps over $120 billion a year were being spent by the Biden administration to, quote, help certain races based solely on their race, assuming that if you had black skin, you were automatically disadvantaged, and that you were entitled to help for banking assistance, or for small business loans, for scholarships, all sorts of a bevy of benefits, and those in the Trump administration now have been effectively turned off. And the federal government has been turned in from a proponent of DEI to an opponent of DEI. And now the fight is moving down to the states, cities, and large corporations that still perpetuate discriminatory DEI programs to supposedly benefit one group and but not benefit other groups.
Talking to someone a couple of weeks ago, and I honestly forget exactly who it was, but the point he was making was that this fight against DEI, the eradication of DEI in both public and private institutions across the country, is probably the most significant public policy shift in decades in terms of the way that government contracts are meted out, the way that the government treats Americans across the country, coast to coast. Do you agree?
Yeah, absolutely. One of our big victories is called MAMCO versus the U.S. Department of Transportation, and we went against the Federal Disadvantaged Business Enterprise Program, which is the oldest and largest affirmative action program. And this doled out about $37 billion a year to minority contractors to build roads. Literally how we build roads in America. The federal law required that at least 10% of all money spent on road building had to be spent on minority contractors. And so roads, bridges, stripers, landscapers, everybody out there putting asphalt down, concrete down, all those went through a lens of discrimination. Also, that we're suing over the 8A program, which is another massive federal program that discriminates based on race. Basically, everything from buying aircraft carriers to paper clips, the federal government was using race as a factor about how they would source and supply those. So yes, we're hearing from our clients that small businesses are really taking notice that there are a whole host of opportunities open to them right now that never were open to them, at least for the past 50 years.
Dan Lennington with us with the Wisconsin Institute for Law and Liberty. will-law.org is the website. So many DEI programs on our college campuses and universities across the country. I know that you guys have done work with race-based scholarships, specifically in Madison, but you also have mandatory DEI training for employees. You have universities, I know University of Illinois did this, and there are others that require DEI statements if you were going to be even considered for employment in those universities. What has Will done on campuses across the country?
Yes, we've sued over race-based scholarships is really the big category. We actually have a case pending that will be argued on Wednesday morning at the Wisconsin Supreme Court that is a scholarship for what they call minority undergraduates. Minority under our state law is defined as Black, Hispanic, and Native American, and Asian, but Asian is defined in Wisconsin as only individuals who are from Laos, Cambodia, or Vietnam. Everyone else is deemed not Asian according to the state of Wisconsin. And this just goes to show you that how they categorize people. They use these broad categories, and we're going to help quote, Asian students, or we're going to help this other group. It shows how discriminatory and illegal it is. And we've also sued the federal government over these types of programs too. But yes, students are left out of getting money for college because of the color of their skin, and that is illegal and immoral.
Dan, we've also seen organizations, entities across the country simply try to change the name of these programs. So they're not technically DEI, or they're not explicitly DEI programs, but they try to achieve the same goals. Are universities, small, government agencies, are they going to get away with simply changing the name of some of these programs?
No, you can't do that, and you can't just change the method. Anytime race is used, it's like putting a drop of poison in a glass of lemonade. You'd never drink the lemonade. Race is a poison if it's used in any way. A little bit of help for this group, a little bit of help for that group, that is illegal under federal law. And we'll come after companies that do that. We have gone after companies that have done that in universities and cities and states. Every time you think you're helping one person because of their membership in a racial group, you're hurting someone else because you're saying that other person is ineligible for that training, hiring, promotion, scholarship, business loan, business grant. Those are all out of bounds for you because of your ancestry, effectively. And that's illegal under federal law.
Dan, paraphrasing Justice Roberts, who said, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. As you mentioned, every time you think you're helping someone, you're actually discriminating against someone else. Thanks to the recent Supreme Court case and the actions of Wisconsin Institute for Law and Liberty and others out there as well, are we perhaps closer than ever to reaching a point where we are stopping discrimination based on race?
Well, I shudder to think about it. Our federal government has temporarily sort of turned the ship around. But another administration could just turn it. President AOC, President Gavin Newsom could turn it right back the other way. And so this victory may be temporary. And the people who are really proponents of DEI, their view is sort of, out of my cold, dead hands, you're going to tear this program. And we've heard this from big corporations. We've seen Northwestern Mutual here in Wisconsin is under EEOC investigation. Nike just got a big EEO investigation, lawsuit filed against them. A lot of these corporations are doing it, and they don't care what the consequences are. They think it's their right and duty to pick and choose what racial groups are, quote, underrepresented or need help. And that they're going to have to face the liability in the courtroom, and they're going to have to face the jury eventually.
You can read this New York Times story from the Sunday edition 2 Sundays ago, and also go to will-law.org for more information about what the Wisconsin Institute for Law and Liberty is doing in this fight against DEI. Dan Lennington, who is Managing Vice President, Deputy Counsel at Wisconsin Institute for Law and Liberty. Thanks so much for joining us this morning on the Steve Gruber Show.
Thank you, Scott. Really appreciate the chance.
Thank you. Scott Bertram sitting in for Steve here on the Steve Gruber Show.